Hi there, I'm Rosemary Barton. Here's what's at issue this week. Alberta Premier Danielle Smith dialed back her pledge on her proposed Sovereignty Act.
When things get decided by the Supreme Court, that we will abide by the decision of the Supreme Court. But you bet, we're up until that point, we are vigorously going to defend every area of our constitutional jurisdiction.
But that fight over jurisdictions is also brewing in Saskatchewan, where Premier Scott Moe unveiled his own plan to defend his province's economic autonomy this week. Two provinces sending a message to Ottawa.
My focus is what it has always been, on working with premiers across the country to deliver the best results for Canadians in their priorities.
So tonight we are asking, are we headed towards a constitutional fight? And what do these challenges to Ottawa mean for the federal government? So let's bring in at issue Chantal Hebert, Elamin Abdelmahmoud, Althia and Andrew Coyne. Good to see everyone. Althia, I'm going to start with you this week. Certainly the new Premier of Alberta hasn't completely walked back from the Sovereignty Act. We'll also have to see what the legislation says. But she does seem to now say that she will kind of generally follow the guidance of the Supreme Court. How are you interpreting her approach to Ottawa in these first few days?
I think it's a welcome step back. I'm sure some of her supporters are probably going to be disappointed. But I think up until those clarifying remarks, there was a real concern that Danielle Smith was going to be disrespecting the rule of law and kind of the system upon which our federation is based. So I think that's a good sign. I think what we are seeing, to answer kind of the greater theme of the question, is maybe not so much a constitutional crisis, but kind of we're sleepwalking towards a federalism crisis. And it's not just Scott Moe and Danielle Smith in the Western provinces who, to be fair, we don't really know what they are going to bring forward. We don't know what the Sovereignty Act is going to look like. But also in Quebec with François Legault, the Premier of Quebec, who is really with Bill 21 and Bill 96, which we have talked a lot about on this program, are challenging norms that we have in this country about not using the notwithstanding clause preemptively, about unilaterally amending the Constitution, which is what Bill 96 does. And I think all of these things added together really paint a picture of federalism in crisis in this country.
I can see Chantal wants in. So Chantal, then I'll come to the other two.
Maybe because I live in a place where saber rattling is the background noise. I'm not sure that we are sleepwalking to a crisis. Yes, the use of the notwithstanding clause preemptively is new. And I, like others, I'm curious to see what the Supreme Court has to say about it and how much trouble it brings or doesn't bring to the Quebec government. But otherwise, I mean, in this province, if you called the bill the Sovereignty Act, the government would lose more than half of the support that it needs. So, and so far, these discussions have mostly amounted to grandstanding to win votes that get resolved in a very boring fashion. So, yeah, it's but it is interesting. But I do believe that it's part of what a federation is, that provinces kick the tires.
Yeah.
And I'll just remind people that the last time the provinces, many of them got together, was to challenge the carbon tax. And what happened as a result of that was the power of the federal government to actually oversee how we deal with climate. And climate change was reaffirmed by the Supreme Court. So if you're going to pick a battle, you may lose the war if you don't pick the right one.
When I talked to Danielle Smith over the weekend, one of the things she talked about, Andrew, was how Alberta didn't want to be the junior partner, which is maybe something she feels and Alberta feels, but it's not something I see reflected here in Ottawa, certainly.
And it's not any reflection of reality. Everyone acknowledges that both the federal government and the provinces have jurisdictional responsibilities under the Constitution. And when the federal government exercises its jurisdiction, it is not making a province a junior partner. It's simply exercising its jurisdiction. So there's a kind of a doctrine in some of the provinces that anytime the feds do anything, they're somehow treading on provincial toes. And I'm sorry, that's not the case. Now, look, there's a difference between a constitutional argument and a constitutional crisis. it's perfectly acceptable for provinces and the federal government to fight over who has what responsibility and argue about it and take each other to court over it. That's fine. What's not acceptable is for provinces and provincial governments to announce that they're not going to obey the law, they're not going to be bound by court rulings, et cetera. And if you read the Free Alberta strategy, which is what the Alberta Sovereignty Act is based on, and remember, one of the authors of that strategy was Danielle Smith's campaign chair, it's quite explicit in saying we're not going to obey federal laws, we're not going to be bound by federal courts, we're going to replace federal judges with provincially appointed judges, we're going to divert federal taxes into provincial coffers. And one of the authors was quite explicit in saying, yeah, the point of this is to bring on a constitutional crisis. Right. So we'll have to see whether, in fact, Danielle Smith is truly going to walk this back. It's certainly a step in the right direction to say she'll be bound by a Supreme Court decision. And if that is true, I think one of the first things that would happen if they bring in this act as it was originally envisaged is the Supreme Court would rule it as being completely unconstitutional, in which case maybe that's what she wants. She can tell her supporters, well, I tried. And then she can still live within the rule of law. But we've got a lot of issues still to resolve in this till we see whether we're out of the woods on this or not.
And when you see someone like Scott Moe sort of jumping on the bandwagon, Elamin, does it then become really about premiers looking for a punching bag, and that punching bag is a convenient Liberal federal government?
Sure. I mean, we certainly have to. There's a necessity of sort of differentiating between normal federalism tensions and abnormal federalism tensions. This country is founded on federalism tensions. That's just what we do around here. I think like when we sort of look at what makes this moment unique, one of the things that does actually make this moment extraordinary is the involvement of Francois Legault in Quebec. And I actually disagree with Chantal about the idea of it being saber rattling because, you know, Bill 21 and Bill 96, I think explicitly are not saber rattling. I think they sort of elevate the sort of, at least the constitutional conversation, the idea that Quebec is able to amend the Constitution and have the Prime Minister say, you know what, they are allowed to do this, even though there are plenty of constitutional experts to say, actually, that is not permitted to do so. I think that is worrying. I think it also kind of dovetails worryingly with this kind of rise of retail politics, where you have a lot of federal politicians who are reluctant to defend federalism locally, whether it's in Alberta or Quebec, because, you know, that sort of guarantees them a little bit more votes the next time around. And I think one thing that we have to maybe ask ourselves is this federal government particularly concerned with the unity crisis at this moment? And if they do find themselves in the middle of one, how will they be responding too late? And I think the answer is already too late.
I'll let Chantal respond, then Althia.
I've seen unity crisis, and this is not what it is. As for the unilateral amendment of Quebec's internal constitution, I'm content enough to wait to see if someone challenges it. And I am reminded that someone did challenge New Brunswick's right to agree with Ottawa that it was a bilingual province on the same basis and the same arguments. And they were told by the Supreme Court to go back home. So I'm with Andrew on one point here. No government in this country at this point has yet said, if the Supreme Court tells us something, we will disregard it. Beyond that, we have seen those challenges before. Bill 21, Bill 96 are protected by a clause that is in the Constitution. You can like it, you can dislike it, you can question its use, but at the end of the day, so far, it's part of the constitutional process.
Should the federal government be doing something more to Elamin's point, Althia? Because to date, the way the Prime Minister is responding to this is saying, we'll work with provinces, we're here to help Canadians about the things that they're worried about right now.
Yeah, I think that's the core question. So far, the federal government has said a few things. On Bill 96, finally, the Justice Minister in the spring said if it came to the Supreme Court, the government would intervene. On Bill 96, the clause amending the part of the Constitution that deals with Quebec, the Prime Minister said he felt, despite the fact that most constitutional scholars outside of Quebec feel that that was not abiding by the Constitution whatsoever, that Parliament should have weighed in. Justin Trudeau said that was fine, which I think is an interesting precedent to set for any other provinces that want to amend part of the Constitution that deals with them. And with regards to the rule of law, the example that Andrew was giving about, Manitoba, Saskatchewan, and Alberta, all saying that they're not going to ask their police force to enforce part of the criminal code that deals with the buyback program or a federal law. Minister Mendocino just said, well, we, trust the police to follow the law. I think what we're seeing, frankly, is that the federal government has vacated the space, and the space has been filled with the forces of decentralization. In Alberta, in Saskatchewan, during the equalization referendum in Alberta, there was no federal voice in that debate. The federal government has been basically absent in Quebec. It's starting to get little by little, but what we're seeing is the more you give to the provinces, the more they want. And at some point, I feel like the federal government needs to defend the idea of a federal government and the federation as a whole. And we have not really seen that from this government.
Oh, okay. About this
can I just say
equalization
quickly?
referendum.
Quickly, Chantal, then Andrew, quickly.
No, but it was a year ago. When did anything happen as a result of it? And the federal government doesn't give to the provinces, the Constitution does.
Andrew?
Can I just say that I agree with Althia on this particular point about the Constitution is not just about the text in it, but the norms and understandings around it, and particularly on this matter, the notwithstanding clause. The courts always talk about the Confederation bargain. What was the understanding at the time of Confederation? And there was a bargain struck in the 1982 process as well, which was that we'd have a Charter of Rights, but we'd have this notwithstanding clause that would be used extremely sparingly and rarely in basically crisis or emergency situations. It was not the understanding at the time, and people who were there at the time will tell you this, that it would be used routinely, preemptively, comprehensively to just basically exempt whole swaths of legislation from the reach of the Charter. And the more that this gets normalized, the more that we're basically eviscerating the Charter and eviscerating the understanding of the 1985.
Okay, very quickly, Chantal, then Elamin, then I'm done.
Second.
Yeah. Yes.
That is all true, except that Quebec wasn't in the room.
That is also true. Elamin, last point, and then I'm going.
No bearing on anything.
Witnessing the norms around the notwithstanding clause kind of being shattered as we speak, right? Like it's been used, 5 times in the last just 4 years or so. That's a pretty extraordinary case. And I think it behooves us as a nation to talk about whether this was its intended use or whether we found ourselves in entirely new territory that actually does, in a meaningful way, threaten federalism.
See how much we love talking about the Federation and the Constitution? That's what we do. We're Canadian. Hey, welcome back to another round of At Issue. The public inquiry into the use of the Emergencies Act started today.
We didn't enter into using the Emergencies Act lightly. We used it with a sense of it was the necessary tool at the time. We used it in a way that was measured and proportionate.
That unprecedented decision will be examined closely over the next number of weeks. 65 witnesses, including the Prime Minister. Tonight, we're asking who has the most to potentially lose, what's at stake for the government or the official opposition. Let's bring back At Issue. Chantal, Elamin, Althia, and Andrew. We're just going to do a quick go around here because you spent so much time talking about the Constitution, but we'll come back to this because it is ongoing until November. Elamin, why don't I start with you here? The government says this is what they want. They want this. It has to happen, obviously. It's required, but the government says it's open to this happening and it wants to see this happening transparently. Is there a risk, though, here for the government?
Of course. I mean, like when we sort of see all the opening statements today, one of the elements of the conversation has been all the passing of the blame to different levels, right? Every single lawyer who spoke is saying, you'll see that my clients, the OPP, did the right thing, but maybe the Ottawa police, they have their own concern. The Ottawa police, speaks up and says, oh, this might be an RCMP matter. There's a lot of passing of the buck, and I think my worry becomes that as we sort of go through these 6 weeks, Canadians might get like a front row seat to a show that they didn't really want to see, which is how many different levels of government either failed or didn't want to take enough responsibility in the matter. Yeah. And I think that is a risk for not just the federal government, but a lot of public institutions that, at least for now, enjoy some kind of public trust.
Andrew?
Remember that this is not a court of law. It's mostly about the court of public opinion. So everyone's expecting the inquiry to make some finding about whether or not the government met the legal standard here of necessity. And it may or may not get into the weeds of that. I mean, it's got to be careful not to tread on the other legal proceedings that are going on around this.
That's right.
And what the public may judge is, if a lot of testimony comes out here that a lot of bad stuff was happening and some pretty bad guys were involved, and the Emergency Act made it go away, the public may be more affected by that than by the specific question of, well, did you meet the actual threshold of necessity? So I think there's risk on the government side that it can look like it came off half-cocked and didn't do its homework on this. But there's also risk for people who associate themselves too closely with the convoy, and I'm talking about the federal Conservatives.
Althia.
Yeah, I agree. I think it's too early to tell which way things are going to go, but there is the risk on both sides. Just today, we learned that the federal government is supposed to consult as per the letter of the law, and it seems like consulting with Alberta and Saskatchewan was really just calling them to let them know that they had made the decision to invoke the Emergencies Act. So that doesn't seem like it meets the threshold. So we in the media will be making those claims, but I don't really think that we know enough yet to judge what has happened. And I'm surprised that there are some people that you would think might be involved in the proceedings that are not, like Doug Ford or anybody political in the Ford government is not being called. That's interesting to me. While there is a large number of federal cabinet ministers that will be testifying. So that's interesting. And I think we can also, what will also be interesting is compare and contrast what has come out of the House of Commons proceedings and the Joint Committee with the Senate about, who asked for this. That was the big question we were talking about in the spring. Will we have the answers that we were missing from that inquiry in this inquiry?
Chantal.
I'll go back to the Court of Public Opinion that Andrew was talking about. Suppose, worst case scenario, the judge says the legal standard wasn't met after having heard about all this. Yeah. Does Pierre Poilievre really want to spend a lot of time in the House of Commons reminding people that he brought donuts to the convoy? In the Court of Public Opinion. So I think the risks are at best even and possibly tilted towards the Conservatives on this one.
At very least, it may include recommendations at the end that make it different or improve it if it ever has to be used again. But who knows if that'll ever happen. Okay, thank you all. That was a very good conversation on both topics. We'll revisit this one. I appreciate it.